On behalf of Sarah Hampson and Tom Cobb, my co-organizers for this speaker series, I want to welcome you to University of Washington, Tacoma, and this event, which is co-sponsored by Politics, Philosophy, and Public Affairs, which is one of the divisions within the School of Interdisciplinary Arts and Sciences, as well as the University of Washington School of Law and the City Club of Tacoma. We're just very delighted to have all of you here, as well as our speaker, Stephen Green. We wanted to say maybe a word about the speaker series in general. This is the first of 3 events we'll be having. And when Sarah and I sort of got together to start talking about this, and then Tom came in the conversation, we were thinking about how to unite a few of the various disciplines that are represented in our very interdisciplinary school. And of course, one of the big issues, especially moving into an election year as we are, is perennially the place of religion in public life, the interaction between religion and politics, and with the recent Supreme Court cases, which we'll be talking about tonight, more specifically, the interaction of religion and law. I think helpfully, in his most recent book, Stephen Green talks about the role of myth in political life, as uniting a people, giving a people a certain identity, and then motivating them to do something, which is certainly something that both religion and law seek to do. So it seems fitting that they would kind of come together and, at times, negotiate over some of the same ground. And so thinking about how we ought to understand those negotiations is one of the things we wanted to do through this speaker series. So, as I mentioned, this is the first of 3. Late February, beginning of March, we'll be having Ludger Bailey, who is a professor at Lemoyne College in Syracuse, New York, who will be talking also about same-sex marriage, but from the more sort of philosophical, religious studies side of the discussion. And then later in probably May or so, we're hoping to have somebody from the Becket Fund for Religious Freedom who is advocating on behalf of American Muslims and the sort of possible complications surrounding religious liberty for that community. So, a lot of fun things coming up. Stay tuned, and we will certainly have the word out to you soon. So now I'll hand it over to Sarah, who's going to introduce our speaker.
Thanks, Eric. Thank you all for coming. I hope you find tonight's speaker as enjoyable as I know I will. So Stephen K. Green is the Fred H. Paulus Professor of Law and Affiliated Professor of History at Willamette University. He also there directs the Interdisciplinary Center for Religion, Law, and Democracy, and he teaches numerous courses in legal history, American law, and politics. Professor Green is also the prolific scholar. He's the author of 5 books, the most recent of which is out this year with Oxford University Press, called Inventing a Christian America, The Myth of the Religious Founding. Professor Green has also served in numerous legal advisory capacities and, for example, has helped draft federal and state legislation that affect religious liberty interests, including the Religious Freedom Restoration Act, which many of you may be familiar with. So tonight, Professor Green's talk is entitled The Tension Between Marriage Equality and Religious Liberty. Please join me in warmly welcoming him to the University of Washington, Tacoma.
Thank you, Sarah. Thank you, Eric, Tom. It's a great pleasure to be here. I haven't been to downtown Tacoma for quite a few years, and I'm really impressed with your campus and how vibrant it seems. So it's a real pleasure to be here. And it's an honor to be here to be giving one of these lectures about the intersection of religion, law, politics, history, those things you're not supposed to talk about in polite company or at the dinner table, right? So hopefully we can talk about them some. Let me just start out by giving the disclaimer that, of course, everything that I say here represents my own personal views and not those of Willamette University. And then also say that I take a position on these issues, and so I don't mean to offend anybody who has a different opinion. I hope you'll speak up on this. I was just thinking just on the way over here about that I'm serving on our faculty recruitment committee, and the junior member of that committee who's brand new was criticizing one of our applicants because he said, well, this article is a little too polemical. He's taking too much of a side on this issue. And I turned to him and said, listen, if you do anything in church and state, you take a side on this. You have to be kind of on one side or the other of these issues most of the time. Anyway, what I want to talk about is this tension that is created to a certain extent by Supreme Court decisions. And you have to apologize in advance that I'm a lawyer, a law professor, as well as a historian, and I'm going to be talking some, at least initially, about two important Supreme Court cases. And it's important to give some legal foundation to these before we get more into kind of more the substantive issue that's at hand here. I've been working in church and state as a student, a scholar, a litigator, a professor for almost 30 years now. And many of the bread and butter issues that everyone was familiar with about church and state, school prayer, teaching of evolution in public schools, public funding of religious institutions like parochial schools, or Ten Commandments monuments on courthouse lawns. Those still exist, but to a certain extent, when it comes to the law, there's a fair degree of consensus on what is permissible and what is not. Those were the cutting edge issues when I first got into church and state. The cutting edge issue today is this topic about how far do our notions of religious freedom, religious liberty go, vis-a-vis important public legislation and regulation in the workplace and in other places with public accommodations, and where we draw the lines. And I'll be upfront at the beginning. I don't really necessarily know exactly where to draw the lines. In the law, we want there to be fine lines many times, clear lines. And this is still a rather new area. And so there's going to be a hazy area that exists on how far these lines, or where these lines should actually be. In some ways, it's going to be a moving target. But let me just talk about these cases a little bit. So, like I said, this talk is about the tension between religious liberty and marriage equality. The subtopic might be why Kim Davis is wrong. Kim Davis being the Kentucky County Clerk who's refused to issue marriage licenses to gay and lesbian couples. And when I say she's wrong, make sure you understand what I'm saying. I'm not saying she's wrong in her own personal beliefs, her own personal religious beliefs. I'm saying she's wrong in her claim that she somehow has a protected religious liberty right to not fulfill her job obligations. We'll get to that in just a minute. Okay. So let me talk about these two cases, because what has happened, many times my students in constitutional law are sometimes confused why the Supreme Court does what it does. And they know as well as anybody else to a certain extent, and they come to realize this the longer they're in law school and out in practice, that the Supreme Court is made up of 9 individuals. And these individuals have their own personal philosophies, their own legal philosophies. They sometimes come together on particular issues, sometimes they don't. We speak about the court, though, as this single entity. The court has ruled. The court has made this pronouncement. And so sometimes the court makes a pronouncement over here, then it makes a pronouncement over here, and they sound completely inconsistent. Actually, the best example is a case I did a friend of the court brief back in 10 years ago, where the court took 2 cases dealing with a question about the Ten Commandments monuments in public buildings, in courthouses. The other one was in the state capital of Texas on their lawn. And the Supreme Court in those 2 cases went 5-4, striking down the Ten Commandments monument in these Kentucky courthouses, went 5-4, upholding the Ten Commandments monument in the Texas state capitol grounds. One justice made the difference. So many times that is what happens. And so what I'm forced to do as a constitutional law professor is try to reconcile these cases, and sometimes it's hard to reconcile. What we have are 2 cases that are on a collision course from the United States Supreme Court. The most recent is the marriage equality case. It came down this last year. Okay. In the marriage equality case, this dealt with a challenge to these state DOMAs, Defense of Marriage Acts, that many states had enacted to try to ensure that states would not issue marriage licenses to gays and lesbians. What happened after a couple of years ago, when the federal DOMA was struck down by the United States Supreme Court, that gave a green light to many lower federal courts, lower federal judges to say, this is where the Supreme Court is going. They're going to actually say there is a constitutionally protected right to marriage equality. So they started ruling in that way. But one of the federal circuits refused to do that, and so the case went to the United States Supreme Court. In a 5-4 decision, written by Justice Kennedy, who's kind of that moderate, conservative, but middle position person, the court found that there is, in fact, a fundamental right to marriage equality. That notwithstanding the long existence of marriage laws that have favored one man and one woman, that actually discriminates against gays and lesbians. That marriage is such a core institution, it's such a core benefit that society provides to individuals. And the state is the one that has to provide this benefit. I mean, I was actually worked on the state DOMA battle in Oregon back in 2004. And we used to say that there were between 500 to 1,000 rights or privileges that come automatically just by virtue of being married. And so as a result of whether you had a domestic partnership law or whatever, still gays and lesbians were not entitled to those rights. And so what the court said, marriage is a fundamental right, and that has a certain legal meaning to it. It means that therefore the state cannot deny that right without showing a really compelling reason for denying it that is very closely tailored of why you would deny gays and lesbians the right to marry when you allow heterosexuals. And the court said the reason is because the same types of reasons we protect heterosexual marriage, intimacy, autonomy, personal choice, these all exist within a gay and lesbian couple's relationship. There's really no difference between those. And so consequently, even though it has not traditionally been protected, all of the indicia of marriage and the reason we protect marriage and call it a fundamental right exist within gay and lesbian relationships. It also noted that marriage is not a static institution. It has changed historically over time. And our perceptions of marriage, perceptions of roles between a husband and wife have changed over time. And so we can't just be set by the virtue of the way that marriage maybe started out initially. But most important, the court said, when you're talking about laws that in essence have a discriminatory effect on gays and lesbians, you're not just affecting them, you're affecting their children. You're placing a stigma on the children, and they too are going to be denied certain types of rights. That affording gays and lesbians the right to marry safeguards children as much as it safeguards the two individuals who are engaged in this marriage. That was the majority ruling. And so it basically means that is now the law of the land. That in essence, any law that is contrary to it or any practice that is contrary to it has to go by the wayside. Now, there's a 5-4 decision, so 4 justices disagreed. They disagreed on several different grounds. I won't get into too many of the technical points. The main thing, I think, was really judicial restraint. This is such a controversial issue. Let's let the legislatures take care of it. Let's not have judges doing it. And of course, the criticism that often happens in these kinds of cases is what? Well, you only have really one justice, Justice Kennedy, effectively deciding what the Constitution says. You don't have 50 different state legislators making decisions about this really important issue. So they said, we need to wait and let legislatures act on these issues. The court then also was kind of critical about the analysis of trying to analogize gay and lesbian relations to marital relations. But to a certain extent, they'd already lost that battle many years ago with the way the court had looked at gay and lesbian relationships and had elevated them in several cases. But one of the main points also that the court, the dissenters talked about, is that by virtue of now finding that there is a fundamental right for marriage, that this may be on a collision course with people who have certain religious beliefs and certain religious convictions, of whether they will then be affected by these laws, such that they may be put between a rock and a hard place when it comes to whether they would follow this law. Okay. Well, they knew what they were talking about, because the Supreme Court, again, as a sole entity, only a couple of years earlier, ruled in a very important case. And this is the Hobby Lobby case. I'm sorry, the first case listed on there, that's the marriage equality case. This is the Hobby Lobby case. And I'm going to go into a little bit more detail here, because this is actually a case about religious liberty. Now, this was a challenge to Obamacare, to the contraceptive care mandate that required all private employers, over a certain number of employees, private employers to provide a host of insurance coverage, including contraceptive care. There's a committee under the Department of Health and Human Services that advises the administration about what are necessary things to include within any type of coverage, insurance coverage. And they clearly said providing for various forms of contraceptive care, that's clearly something that should be included in all these health plans. Now, this case was touted as several different things, kind of interesting. Some said, oh no, it's another challenge to Obamacare. Some also said this is the next line on religious liberty cases. Some also said this is also the next stage in a case called Citizens United. I'm sorry, I'm throwing too many cases out here, I realize. But you may also remember what Citizens United is, because it's very important. Citizens United was a free speech case, also coming under the First Amendment, free speech case several years ago, where the Supreme Court extended free speech protections in a way it had not before. We're not getting into technicalities here. To corporations to engage in political speech. And the court for a long time has said one of the main ways that you engage in political speech is your ability to make contributions to a political candidate. And it basically gave a green light to large corporations providing unlimited sources of funds for political campaigns. Got a lot of media attention, a lot of people complained. And one of the things they said is, well, wait, a corporation is different from a person. Why, if I have a free speech right, does a corporation have a free speech right? This was part of the controversy. Well, the reason Hobby Lobby was seen as an extension of that is because the plaintiffs in Hobby Lobby were Hobby Lobby, which I passed one coming up from Salem today. Right? We just got our first one in Salem, not in Salem, in Oregon. 500 stores nationwide, 13,000 employees. In essence, it's a home, what do you want to call it, a hobby place, right? Where you can get your various types of creative crafts items. A nationwide chain. Happens to be privately held by a family named Green, no relation to me. But they, in essence, by being privately held, means it's not publicly traded. It's not on the stock market. But it is still a for-profit business. And a for-profit business created not for the purpose of any kind of religious ministry. It's not a religiously oriented business, even though it has a lot of religious things in it. And the owners are religious. Here they were claiming that the businesses' free exercise rights would be violated if they were required to provide certain types of contraceptive coverage for their employees. So it raised the question, can a business actually make a free exercise claim? Can a business have a religion? Can it have a faith? Now, one of the things you have to remember is the reasons, and I'm not a corporate law person, but bare minimum my understanding about corporate law is, one of the reasons we created corporation laws back in the 19th century was to provide a certain amount of distancing from the owners of the business from the business. And we create a separate identity, a separate legal identity for the corporation. The Greens are sincerely opposed to certain types of contraceptive coverage. There's actually another plaintiff in the case, Conestoga Woods, a woodworking outfit that has about 900 employees, also closely held, not publicly traded, owned by Mennonites. And they also objected to providing certain types of coverage too. So the question was, in both cases, because these were businesses, were the businesses themselves burdened in their religious beliefs by virtue of having to provide certain type of coverage which their owners were sincerely objecting to, had conscientious objections to? To a degree, there's a case of first instance. Okay. So this is what the court had to consider, in essence. As I said on a couple of radio interviews, can McDonald's pray? Can a business have a soul? Okay. So the court, in a very divided decision here, it was really, in a sense, 5-4. There was an important dissenting, concurring opinion in the middle by Justice Kennedy. But the court said yes, said in fact a business can raise a free exercise claim. Now, I need to become even more technical than I've been. Part of the problem with this case, or at least part of the problem with this area, is that this case was actually not brought under the Constitution. There's a federal statute, as was mentioned, the Religious Freedom Restoration Act, or RFRA, is the shorthand version for it, that was enacted in 1993 by U.S. Congress. The reason it was enacted is because in 1990, the U.S. Supreme Court had actually ruled in the case coming out of Oregon that a law, what we call a general applicability, it means a law that is not oriented toward religion, it's just a general law, but still applies to religious organizations. do you give religious organizations an exemption from compliance with that law if they have a religious objection to it? And the court in that case said, no, we're not going to do it. It dealt with a couple of drug counselors who were also members of the Native American Church. They ingested peyote as part of their religious belief system, their sacrament, and they were fired from their job as taking drugs, actually charged with criminal drug possession. And they wanted to raise a free exercise claim, saying, hey, we should have an exemption from this law because of our religious beliefs. We're not taking these drugs to get high in the sense of what people do. We're taking them for their sacramental purpose. Went to the Supreme Court said, no, government doesn't have to show any type of additional reason to whatever sanction you under this law. We're not going to recognize a free exercise claim here. So what Congress did in 1993 is they wrote this law. And they wrote this law and said, when you have a religious objection to a law that is generally neutral, applies across the board, generally applicable, facially neutral, that the government still has to use a higher standard of review, has to show a compelling reason for why this law should apply to you, and also explain why the government can't give you an exemption from the law, even though they're requiring other people to adhere to the law. So that's what Hobby Lobby was claiming. Hobby Lobby claimed because this was Obamacare, which is federal law. The Religious Freedom Restoration Act actually applied to Obamacare, such that even though Obamacare, facially neutral across the board, all businesses, doesn't matter what you are, you have to provide contraceptive coverage, shouldn't apply to us. Why? Because we have a religious objection to this. It's the corporation that has a religious objection to it. So what the court had to find first is a corporation a person? Can a corporation actually raise a religious claim? The court kind of danced around this a little bit and actually said, well, there's really no reason not to have a corporation be able to raise a religious claim. They actually found one case where, back in the 1960s, where the owner of an Orthodox deli, who was Jewish, Orthodox Jewish, had filed a lawsuit against a Sunday closing law, and said it burdened his religious beliefs because he was forced to be closed on Saturday because of his religion, and forced to be closed on Sunday because of the law, and he was at an economic disadvantage. Went to the United States Supreme Court. The Supreme Court actually ended up dismissing the case. They said, you don't have a strong claim. But Justice Alito, who wrote the Hobby Lobby decision, said, aha, but no one ever questioned at that point in time whether that business could raise the claim. So therefore, we have what we call precedent. So there's one case out there that gives precedent for why maybe a corporation can raise a free exercise claim. The other thing they did is they looked at this law, the Religious Freedom Restoration Act. It uses the word persons. And since there's nothing that excludes corporations from that law, the law doesn't say anything one way or the other about corporations. So we're going to just assume that corporations should be included as a person under the Religious Freedom Restoration Act. I said, after all a corporation is just a bunch of people getting together, organizing for their common purpose. And so there's really not a whole lot of difference between a corporation and a person. Now, what was troubling to me about some of that analysis is, and I think Justice Ginsburg made a really, really good point. In fact, I usually don't read from a case, but let me just read what she said in response to this idea of corporations. She says, a corporation is an artificial being, invisible and tangible, existing only for the contemplation of the law. Corporations have no consciences, no beliefs, no feelings, no thoughts, no desires. The reason why this should not apply to a for-profit business, the free exercise right, is, she said, religious organizations exist to foster the interest of persons subscribing to the same faith. Not so for for-profit corporations. Workers who sustain the operations of these corporations commonly are not drawn into one religious community. In essence, she's saying Hobby Lobby is not a religious community. It doesn't have a religious purpose. It doesn't have the same functions as why we provide free exercise protection for individuals of faith or for religious communities. They're very different types of entities. And we shouldn't so quickly make corporations into religious entities. And actually, as someone who has worked very closely with religious organizations for many years and served on the National Council of Churches Religious Liberty Committee for a long time, I argue that this actually is almost the dumbing down of religion. In essence, religion in this instance, therefore, loses its significance, loses its distinctiveness. If almost any institution now can be equivalent to a religion, at least for the protection of the law. In essence, as a historian, I believe that the founders actually put something in the Constitution. They purposely said, free exercise of religion, no establishment of religion. It's the only type of philosophical, ideological belief system that is singled out for recognition in the Constitution, at least in the First Amendment. In essence, the government can speak politically. It does all the time, depending on who's in office, right? It can speak artistically. It can speak about economics. But it seemed like the founders were basically saying something about religion is a little bit different here. And so therefore, the government shouldn't be interfering with religion or doing religious type things. Religion is somewhat distinct. Now, you may disagree with that on one level or the other, but the point is that's what the First Amendment says. And without a doubt, by virtue of allowing for-profit businesses that are not for the purpose of any type of religious function or ministry to actually now raise a religious claim, it does seem to be kind of the debasement of religion. Another reason I disagree with having a free exercise right for corporations is because, as Sarah mentioned, I actually helped write this law that they were relying on, the Religious Freedom Restoration Act. It was a broad coalition of civil rights and religious groups who got together. This is when I was working in Washington, D.C. And we came together for very, very many different reasons. I was involved in it in order to try to make sure there was religious liberty protection for religious minorities. I'm not just saying the other side was not concerned about that, but we came with various different agendas into this. And we were able to draft this law that basically everybody agreed on. But it's a very tenuous coalition. ACLU on one side, Homeschool Legal Defense Fund on the other side, way across the board. Okay. I can tell you from my own personal memory, if anybody in all of our coalition meetings or when we were actually presenting the bill, as we wrote, to Senator Hatch and Senator Kennedy, the two co-sponsors of this bill, if anybody had said at any point in time, and oh, by the way, this law is also going to protect for-profit corporations, the law would have never gotten passed. There's no way that would have survived the coalition. There's no way Senator Kennedy and Senator Hatch would have agreed on that. But unfortunately, that's not explicit in the legislative record. And so as a result, the court said, corporations have a soul. Once you found corporations have a soul, and to a certain extent, this is distinct from the owners of the corporation, then the question was there religion burden? And I'm going to get to this a little bit later, and I'll pick it back up again. The court really said, well, of course their religion's burden because the penalty for not complying with Obamacare is thousands and thousands of dollars a day, and it's per employee. And I think with Hobby Lobby, the potential penalty was going to be in the $400s of millions of dollars for just 1 year if they didn't provide this coverage. And the court said, that's a burden. Now, I disagree with that way of analyzing it. The burden should be on the religious compliance with the law, not on the penalty. To me, that's the confusion of two separate or related issues, but two different issues. I mean, once you show that you have a burden, then there may be a penalty will attach. But you need to explain how complying with the law in and of itself burdens your religious practice of the corporation. We'll come back to that in a minute. Once that happens, then the burden, in a sense, shifts to the government. The government has to show they have a strong, compelling reason for enacting this law. The court said, oh yeah, maybe contraceptive coverage is important, Obamacare is important. But you know what? It's not tailored. And what that means is there are other ways you could exempt this entity, these businesses. And part of the reason is there already was in the law some exemptions from compliance with Obamacare, with the contraceptive coverage, for religious institutions, for houses of worship. And so what the court said is because you can give an exemption to them, there's no reason you can't give an exemption to these for-profit businesses. As a result, they can, in fact, raise this religious claim, and of course, they prevailed on this religious claim. Now, why this is important, and we'll be getting to this, is because, of course, even though the court was talking about a for-profit but closely held business, and they said, that's all we're really talking about in here, the court really did not put any real constraints on how far this principle will now go. And actually, I talked to some of my colleagues who teach business law, just to get this confirmed, and what I understand is actually in the United States, between 85 to 90% of the businesses actually are not publicly traded in this country. It's a very small number of businesses that actually are on Wall Street. So we're talking about a large number of businesses throughout the nation that actually are for-profit but are privately held businesses. Now, so far as employees are concerned, I think it's about 45, 55, something like that. The big big corporations certainly employ a whole lot more people. But still, in any town, you're going to find mom and pop stores, a host of businesses that are not publicly traded. What does this mean? It means this decision basically allows for individuals who own certain businesses that are, in fact, these businesses are incorporated, still to make decisions based upon their religious beliefs of whether they want to comply with certain important laws that exist in the workplace. These could be things like wage and hour laws. These could be non-discrimination laws and employment laws. These can be laws that affect public accommodations. What we mean by public accommodations in the law, it means any business is basically open to the public, to serve the public. Restaurants, hotels, shops, etc. Now, you're a little far away from Portland to probably be paying attention to Portland news, but there's been a controversy going on in Portland for the last couple of years about a bakery called Sweet Cakes Bakery. And Sweet Cakes Bakery is owned by a couple of people of devout faith, and a lesbian couple came in and said, we'd like you to make a wedding cake for us. They said, no, we would not want to be complicit in making a wedding cake for a couple. The lesbians are going to be married, would somehow be complicit in either recognizing or approving of that relationship, and so they refused to do that. This case has actually gotten some national attention. They've now been, they were then sanctioned by the Bureau of Labor and Industries, which is our employment discrimination branch in Oregon, and I believe they were fined about $150,000, some significant amount, which I think is actually a little high, for this. And so they're filing a suit and claiming that, in fact, this is a violation of their free exercise right, that they can raise this claim even though it's the business is the one that is being charged with this form of discrimination. So this is where the rubber is kind of hitting the road these days. There's one other issue that comes in on this case dealing with Hobby Lobby too. And this has ramifications across the board with businesses in some respects, but with other entities that might want to raise claims of a religious exemption to comply with non-discrimination laws or public accommodations laws. And we made this claim in Hobby Lobby, and it's actually coming up again in some new cases that the Supreme Court has just granted cert on of a similar nature. And that is what we call the third-party burden that exists in this. And traditionally, the way the court has talked about religious accommodations, if you're going to accommodate someone's religious beliefs against a otherwise valuable law, important law, that's neutrally applied, then we need to look at how accommodating that person's religious belief affects, if you want to call it, innocent third parties. In essence, and who are the innocent third parties in this case? On Hobby Lobby, they were the employees that were now not going to have contraceptive coverage in their insurance plans and would have to go out and purchase it over the table. And a brief that I wrote at the Supreme Court with some other law professors said, this is a consideration you need to take into this formula. In essence, even if you are going to find a corporation as a person, has a free exercise claim, and there's a burden on their religious beliefs by complying with this, we still need to look at the effect of giving that entity a religious exemption and how it affects third parties, this being the employees. The Supreme Court kind of sidestepped that issue and said, well, because there's this availability of this applying the religious exemption to the corporations, which has this out for the insurers paying for the coverage themselves, we're not going to say there was actually a burden on these women in this particular case, so we're not going to say it's necessary. But what we argue in the case, though, according to the Guttmacher Institute, which tracks different aspects of abortion and contraceptive laws, is that many of these contraceptives, many of these women, would be having to shell out as much as $1,000 a year in order to buy these contraceptives over the table, instead of having them provided by their insurance. So if you're working for Hobby Lobby, and you're making, and they do pay you a little bit above minimum wage, but you're making not that much above minimum wage, that can be a significant financial burden on you. And the point is that, in essence, in order to accommodate the religious needs of the owners of Hobby Lobby, that they are basically transferring the cost of that, and I'm not an economist, but transferring the cost of that accommodation onto their employees. In essence, the employees, who may or may not agree with their religious beliefs, are subsidizing the religious beliefs of their employers. At least traditionally under the law, the court has said No, you could accommodate someone's religious beliefs. That's good, and we should be doing that. But when you have someone else have to pick up the tab for that accommodation and places a burden on them, that's maybe as far as we're going to go. We're not going to go quite that far when it comes to religious accommodations. Well, the court really did not succinctly answer that question, so that is still out there. But why is that a problem? Or why is that an issue? Well, it may depend on where you live. It may not be an issue in some places and other places. If you can raise a claim that you want to be exempt from a law because of your religious beliefs, if you're a pharmacist and you're working for Walmart and you disagree on sincerely held religious beliefs, I think many people do, about dispensing certain types of contraceptives, should we accommodate that pharmacist? Well, I actually think it might be okay to do that. I think it might be good to do that if there are a number of pharmacists in that pharmacy who can then provide that service. Right? I think we actually are better as a people if we can realize the religious diversity that we have and people don't necessarily agree on all issues the same. What happens though if you're a pharmacist in the only pharmacy in Eastern Oregon or Eastern Washington, and you on your religious grounds, and once again, these are sincerely held religious grounds, but you object to the dispensing of these items, then what is that person required to do? They're required to drive a significant distance to try to find a place where they can receive these services. So that's creating a burden on innocent third parties in a way that is effectively subsidizing the religious beliefs of that individual if we exempt them from these laws. So this becomes part of the problem that exists out there. Let's talk about let me hold off on Kim Davis for just a minute. Let me talk about one other technical factor that's problematic in here. And that goes back to that question about what is a substantial burden on religion. Okay. Under Obamacare, under the requirement that you provide for contraceptive coverage, these plans, these insurance plans that people were purchasing, right? Businesses were purchasing, the way that they work in the vast, vast majority of the cases is that there's no additional cost to the employer to include this contraceptive coverage. It's part of a general package deal. Right? And so the fact that they are actually providing for contraceptive coverage is not financially burdensome to them at all. There's no additional financial outlay when it comes to Medicare Part D. So what is the burden? Well, the burden is that I have a plan. I'm religiously opposed to contraceptive coverage. Right? I have a plan that I know that some of my employees may be able to access this, may be actually able to get this coverage. And so I'm facilitating them in engaging in conduct with which I disagree, which I'm morally and religiously opposed to. I invite you to question the extent of the burden that exists in some of these cases. Okay. Several reasons. What does the employer really know? The employer knows that they actually have contraceptive coverage in their insurance plan. Do they know at any particular point in time whether any of their employees are actually accessing that coverage? No, we have something called the federal HIPAA laws, which prevent your employer from actually knowing your personal medical history or what you're taking, what type of drugs you're taking. They know that they're offering these drugs under the insurance plans, but they don't know from one day to the next whether any of their employees are actually going to be utilizing these drugs. So what is the religious burden? The burden is just having it in the plan. The burden is somehow, as the argument has been, that we are somehow complicit in this conduct with which we disagree. It's a case I worked on many years ago out of California that dealt with a very devout woman. And she owned a small apartment building, this small complex. And she was very devout, and she did not believe in gay relationships. She didn't believe in people living together who aren't married. And so she refused to rent any of her apartments to any couples she thought were gay or to unmarried couples. And the reason being is that she believed that it was sinful to engage in that type of conduct and that she would somehow be complicit, facilitating that conduct by renting an apartment to them. She was charged with violating the California Fair Housing Law, the UNRRA Act, and was fined, goes to the California Supreme Court. And I wrote an amicus brief at the California Supreme Court and said, I invite you to just consider what is the nature of her religious burden here. Her religious objection is, I believe that gay sex or unmarried sex is sinful. It's to a degree somewhat speculative. One couple who brought this case actually came up front and said, yes, we're not married. Kind of speculative. You went to two men or two women. Are they gay? Are they lesbian? She didn't necessarily know. She didn't know if they're actually engaging in sex at any particular point in time. Her injury was really a psychic injury, a perception that something was going on here with which she disagreed. How is she complicit? What is she doing? She's renting an apartment. She's not encouraging sex. She's not encouraging any particular type of conduct. And the California Supreme Court agreed. Said there was not a substantial burden on her religious beliefs just by virtue of renting apartments. She herself was not engaging in anything immoral herself, and she was not forcing or encouraging anybody to engage in any kind of immoral activity. So back to the Hobby Lobby case, and these similar types of cases. Where is the religious burden? Now again, this is a difficult issue, I realize. Some of these cases have come up where a wedding photographer, case out in New Mexico, a wedding photographer, again, a devout religious beliefs, did not want to take wedding pictures of a gay or lesbian couple at this point. Right? And said, no, because this is kind of artistic what I do, and also that my name is always on the photos, or at least people know who I am. There may be some indication, or someone may believe that I'm promoting this particular type of conduct. I'm condoning this particular type of conduct. The New Mexico courts have rejected that argument. But still, you can see maybe in potentially some businesses, there could be something where you could see someone being closely identified with conduct with which they disagree. But in many other businesses, they're not. And by virtue of just baking a cake, by virtue of doing a host of other types of things where someone comes in the door, you're not necessarily encouraging that activity. So the injury to yourself, like I said, is primarily kind of a psychic injury, that I know that this is going to happen. To the extent to which this person is actually being burdened themselves, the religious burden, it seems a little removed, tangential. Let's go to Kim Davis. Kim Davis was the county clerk, Rowan County in Kentucky, I believe, where she's very devout religious, and she's an elected official, and she refuses to issue marriage licenses, right? What you do, a couple comes in, you issue the marriage license, they go someplace off and get married, maybe they get married there by one of the clerks, who knows, they don't have to get married there, right? So she did not necessarily have to perform the weddings. All she was doing was just issuing these marriage licenses to this couple. But she was saying, I am complicit in this somehow. That my name being on the marriage license somehow indicates either I'm approving of this or I'm promoting this, and I'm religiously opposed to gay marriage, which she is sincerely religiously opposed to gay marriage. She was held in contempt of court. She was in jail for 7 days. She initially was refusing to let any of her lower clerks actually give these licenses. She finally conceded that, but she's still been kind of in the mix here and saying, my free exercise rights are being violated by virtue of the requirement that I fulfill my job obligations and fill out these marriage licenses. I'm somehow complicit in this. Well, again, she needs to tell us what the burden is on her religion. Okay, how is she complicit in this? Well, I can give you a personal story. Many, many years ago, when I first started practicing, I was actually practicing in Alaska and ended up becoming a magistrate judge in the Alaska court system. And it's a very busy court where I was, and I was on the bench almost all day long doing DUIs, minor assaults, these kinds of things. But one of the things of my responsibility, one of my other responsibilities was I actually oversaw our court clerk's office. I had 7 clerks under me. I had a chief clerk who really ran the office, but I was technically her superior, her boss. And one of the things I was authorized to do was to perform marriages. The chief clerk could perform marriages, and then we had one other clerk who could perform marriages. So there were 3 of us who were authorized to perform marriages. They usually did most of it, because I was on the bench most of the day. But many times one or the other was busy doing something else, and they would call me and see if I would do a marriage. And normally it was at my lunch hour, and I knew I was going to go back on the bench later on in the afternoon. I really hated doing marriages, but it's part of my job. Okay. I'll give you the traditional scenario, and I'm not trying to be flippant here. Traditional scenario. It was, call me, Judge Green, we have someone who'd like to get married. Can you do this? Okay. I knew what it was going to be. Because it was at lunchtime. Who gets married at lunchtime? Gets married at lunchtime, someone who gets off for their lunch break to get married. Inevitably, the woman showed up with one of her best friends, wearing her nicest dress, wearing a nice little bouquet of flowers. Most important day of her life. The husband is running a little bit late because he's coming from work. He shows up in his work clothes. And I would normally say, because I had these prepared, what I call them, anyway, things I say for a wedding. You know, I say, would you like the longer version or would you like the shorter version? And inevitably the guy said, short version, look at his watch, we get this over with. I hated doing those weddings because I just knew, I always had these bad feelings that these guys, I mean, about half the time the women were pregnant too. It's kind of like, you know, this was not a marriage that I would want to put my stamp of approval on. And in fact, I had several of these people in front of me later where I was doing the divorces. But you know what? I did it. It was my job. I was almost morally opposed to providing some of this. I mean, I got to where I'd call my clerk and say, would you please do this? I just don't like doing this. It kind of gives me the creeps. But I did it. Now, if you told me that somehow by virtue of my name being on that marriage certificate, that I was condoning that relationship, that I was facilitating that relationship, I was encouraging that relationship, I probably would have laughed at you. I'm doing my job. I may disagree. I may not, you know, I may have my suspicions. I don't want to marry that couple. But this is what I need to do. But there's no way that I am complicit in whatever conduct they're engaged in as a public official. This is why I think Kim Davis is wrong. She may have a sincerely held religious belief that gay marriage is incorrect. But one, she has a job she needs to do as a public official. But then two, I really still don't see what the burden on her religious beliefs is to do her job. Now, I'm not sure exactly where that status of her controversy lies at this particular point in time. But this has become the new, main controversy within church state. It's been the extent to which people of faith, whether engaged in a business, whether engaged in some type of public position as a public official, can at some point in time say, my religious beliefs tell me that I should not be able, or I should not be required to follow the law, non-discrimination law, housing law, public accommodations law, or provide the services that I'm required to do by virtue of my job. Because if I do, I am somehow complicit in the conduct. Now, I agree. I think in some instances, maybe we should at least think about this. After Roe versus Wade in 1973, Congress passed something called the Conscience Clause. And the Conscience Clause was connected to federal funding for hospitals. And it basically said, and all hospitals get federal funding. Okay? So it basically said, if you're either a religious hospital, a Catholic hospital, or you're a Catholic doctor, then we're not going to require you to perform an abortion because that's against your religious beliefs. I can agree with that accommodation. To force a Catholic doctor to actually perform an abortion, that's against their religious belief. It's not psychic. I mean, they're directly involved in that event. Right? That is a burden on their religious beliefs. But there's a continuum here. We should not necessarily think that everything that offends your religious sensibilities, day in and day out, rises to the same level of that burden just because you may be offended. Under Fourth Amendment law, search and seizure law, you're learning a lot today. Fourth Amendment law, there's this old concept called reasonable expectation of privacy. And it basically means, the example I used to give is smoking marijuana. We can't do that in Washington and Oregon anymore. Anyway, smoking marijuana publicly, right? And a police officer stops you and says, you're violating the law. He says, you're violating my privacy. Well, no, how could you expect when you go out and do something that publicly that you somehow have a right of privacy to protect yourself from the way the law is applied? People do not enter into the commercial marketplace with the expectation that they're going to be immune from an increasing number of regulations, safety regulations, right? Health and safety, employment regulations, etc., many of which they may find offensive. many of which they would rather not comply with. I'd rather not pay minimum wage, right? But you know what? You do it because those are the expectations. Those are the costs of running a business. So when you have that realization of entering the marketplace as a purveyor of some type of service, some type of business, the ability then to exempt yourself here and there based upon your religious beliefs. And once again, what we're talking about is corporations, businesses. Those are the ones that are actually going to do that. I really wonder the extent to which that is something that the society should necessarily be encouraging for us to do. Again, I don't have the exact place to say where these lines will be drawn. This is going to be probably meted out in a lot more litigation. The Beckett Fund is actually one of the main groups that's been promoting many of these claims. And so we'll have a long way to go. But to a degree, what it is, it goes back to my initial thesis, is that this is a conflict not the Supreme Court created per se, but on one hand they said there's this right to marriage equality. On the other hand, they defined kind of forgive me if I say this, an exaggerated view of what is actually a violation of someone's religious beliefs when it comes to sincerely held religious beliefs. And there's a conflict there. And the Supreme Court is going to have to resolve that conflict. Now, just one last minute. What's before the court right now are 7 different lawsuits that have been consolidated. That these are not by for-profit businesses. These are actually by religious organizations. Little Sisters of the Poor is one of them out of Colorado, many other that run kind of charitable social service, schools, a variety. But these are all religious institutions and religious universities. They already now, as a result of some expansion of the Obamacare regulations, they already qualify for an exemption from contraceptive care coverage. So they don't have to provide the coverage. What they're objecting to is filling out the piece of paper that says, I want to be exempt from this law. I said, by virtue of filling out the form, they are actually, once again, providing the avenue, or there being the mechanism for their employees to then go get contraceptive care through the insurer directly without the religious organization being involved. So these are the cases for the Supreme Court. Now, as someone who's litigated cases at the Supreme Court, I'm a little troubled by that because almost all of the circuits said there's no religious claim here. One circuit has, but the court actually granted cert before that circuit ruled. I don't necessarily see the religious claim here. In essence, that I want an exemption from the law based upon my religion, but I don't have to tell you that I want that exemption from the law. Or somehow I'm complicit in violating my rights by saying, relieve me from compliance with that law. I think that's a very tenuous free exercise. So this is my concern. There's a lot of confusion going on right now with the law about exactly what is a religious burden. And it's going to take a while for the Supreme Court to work this out. I'm not sure I'm that optimistic, but we will see. So stay tuned. So thank you for bearing with me with kind of some technical discussions here.